Our first speaker this morning is the very well-known Earl Cherniak, and he is going to be speaking to us on damages in tort personal injuries cases. And indeed, there is probably no one more appropriate to do so than the man who pioneered and broke the new ground in the famous Tino and Arnold case, and to whom we therefore owe very considerable debt in this area, if for no other reason. Earl was a gold medalist at Osgoode Hall Law School, won the Chancellor Van Conant Scholarship, and immediately after that he was the legal secretary to Chief Justice McCruer for a year. He then joined the Lerner firm in London, where he is now the senior partner in litigation. And among his other assets and holdings is, I understand, a controlling interest in the List at London. He has been that's a London in-joke. At Western, he lectured in municipal law and in remedies, and gave other lectures from time to time. You may recall he was the commission counsel to the Royal Commission on Metropolitan Toronto Police Practices. And that was in Toronto from 1974 to 1976. He was honored by being elected the president of the Advocate Society, and is in fact the immediate past president. He's the director of the Victoria Hospital in London, and has served also as a member of a number of special committees that have been set up by the Chief Justice to study particularly vexing problems in this area of tort compensation, such as the committee that was set up to fix the capitalization rates in damage actions, and the committee on tort compensation that ran from 1979 to 1980. So it was with great pleasure indeed that I introduce to you this morning Earl Cherniak.
You can't pay much attention to what Burke Doran says about me, because he's the only lawyer I ever hired, so I think he's prejudiced. Where I really learned about damages in personal injury actions was, in personal injuries, was when I was commissioned counsel to the Royal Commission on the Metropolitan Toronto Police. That's where I learned all about it. A few areas of the law have changed as dramatically in the last 20 years as this field, tort damages in personal injuries. In 1966, just 15 years ago, a jury in British Columbia, in the case of Bisson versus Powell River, awarded a young quadriplegic $286,000. One of those global assessments, but it was done by a jury. And the British Columbia Court of Appeal, in discussing that award, the case eventually went to the Supreme Court of Canada, said that that award of $286,000 was the highest single award that had ever been made in England or Canada. They then proceeded to reduce that award by $90,000 on the basis that the trial judge had suggested to the jury that they might consider that inflation in Canada would increase by 3% per year, and they should take that into account. The Court of Appeal said we can't have any of that kind of thing, and they reduced it. And the Supreme Court of Canada did not interfere with the British Columbia Court of Appeal on that point. In 1974, when the so-called trilogy of cases came before three separate trial judges in Ontario, British Columbia, and Alberta, $1 million liability insurance coverage was really quite uncommon for motorists or for anybody else. Now, in 1981, I suggest to you that, and it was recently suggested at an Advocates Society panel, that $2 million coverage is probably not enough. In the present state of the law, a $500,000 award for a single death is quite possible. Some cases have been settled recently for a single death of a young wage earner at that amount. And in the next 5 years, I am confident that we'll see a number of $2 million awards, or awards in that range, for a single personal injury. I propose in the paper that I've written and in this lecture to review how the law has developed in the past 20 years from the intuitive guess of the global award made by judges, which, in my view, always undercompensated injured plaintiffs, to the present rather sophisticated projection made by judges over a long period of time of such things as the cost of future care, loss of income, inflation, income tax, productivity, negative and positive contingencies, so as to provide a full indemnity with some reasonable degree of certainty. I propose as well to review briefly some recent developments, such as the claims under the Family Law Reform Act, interest, and structured settlements. This lecture today will be a very much abbreviated form of what I hope is a good deal more scholarly paper. I hasten to say at this point that the paper is the product of my own work and of my associate, Mary Ann Sanderson, whose first act as a student in our office was to attend the trial in Tino versus Arnold, and who has been involved with me in every major personal injury case that I've handled since that time. I'm responsible for all the errors and what I say today, but she's responsible for all the errors in the paper. Almost alone among the major changes in law reform in this country, the changes in this field are almost entirely judge-made. Interestingly, though, the theory hasn't changed. The basis for compensation in these actions is the same as it was back in 1880 when Lord Blackburn said this, dealing with compensation for injuries. He said, "You should as nearly as possible get at that sum of money which will put the party who has been injured, who has suffered, in the same position as he would have been if he had not sustained the wrong for which he is now getting his compensation or reparation." The methods of getting to that goal, however, have changed very radically. Prior to the trilogy, the results fell far short of this goal. Judges were not required to break down their awards, and indeed it was not considered proper to do so. As recently as 1965, in the case of Jennings versus Kronsberg in the Court of Appeal, Mr. Justice McKay said this: "The better course to be followed by a judge sitting without a jury is to state the heads of damages to which he has given consideration in fixing the general damages awarded, in order that there may be no doubt that he has taken into consideration all relevant factors, but not to allocate specific amounts of money under each heading." Appellate courts in this period interfered only when there was error in principle, which meant really that a judge failed to mention one of those magic heads that he had to think about when he was making his guess of damages, or when the assessment was wholly wrong, or when it shocked the conscience of the court. Those of us who were arguing before the Court of Appeal in the 1960s in this province know that they were pretty hard to shock, although there wasn't any difficulty in them shocking counsel. In the 1970s, a number of things came together all at once that effected the dramatic change that we've seen. In the first place, medical science made some of these very, very severely injured young plaintiffs survive long enough to make the damages interesting. Some of them got injured by defendants who could afford to pay large sums of money. Inflation became rampant like it is now, and people realized that something had to be done about it or there was going to be a tremendous shortfall. And most importantly, the courts came to be composed of lawyers, of judges who had been lawyers, in some cases for plaintiffs, who knew in their practice that they weren't getting enough money for their seriously injured clients, and by lawyers who had been lawyers for insurance companies who felt once they got on the bench remorse and guilt for all the terrible things we can all think of judges who fit one of those two categories, some of them both. At any rate, for whatever reason, in the early 1970s, a number of cases were decided in Canada that used this rolled-up global general damage award, but got into some figures in the $150,000 to $250,000 range, albeit no breakdown. Then the case of Jackson versus Miller that came along, and that was in the early 1970s. I think it was tried in 1971, got to the Supreme Court of Canada about 1974. In that case, Mr. Justice Osler made a breakdown between the so-called non-pecuniary general damages and the pecuniary general damages. He didn't really call it that, but he made a separate assessment in that case of the loss of income of that unfortunate quadriplegic and the cost of hospital care over his estimated lifetime, came to about $95,000, rounded off, and he awarded that sum plus $150,000 for the other, under the other rolled-up heads of general damages. He didn't do anything about inflation or productivity or income tax or any of the things that we think about now, but he did make that breakdown. The Court of Appeal at that point would have none of it, and they said he didn't think about contingencies and a lot of other things, and they cut down the $95,000 by $50,000. The Supreme Court of Canada, Mr. Justice Spence, restored the $95,000 and said that the judge was right to, on the evidence in that case, to make that kind of a breakdown. And that, I think the Jackson versus Miller case was an important case in that line. The English Court of Appeal was wrestling with the same kind of problem, and in a couple cases that I've cited in my memorandum, they said that the modern practice was to assess each head of damage separately so that the parties could see how the damages were calculated and could challenge the assessments on appeal. That was in one case in 1970, one case in 1973. In 1973, there was a case in Alberta, again one of these rolled-up awards for quadriplegic, $350,000, which was the largest award in Canada up to that time. And then in the spring of 1974, in these three separate provinces, the so-called trilogy of cases came before various trial judges in the three provinces, and all the judgments came down within about 3 months of each other. And the damages that were awarded ranged from $1 million approximately in Latino versus Arnold and Andrews, which was the Alberta case, to $1.5 million in the Thornton versus School Board case in British Columbia. Now, as I say, the highest award up to that point was the year before, $350,000, and all of a sudden, three separate judges in three separate provinces, three separate cases, awarding damages $1 million to $1.5 million. That was really a dramatic and astounding quantum leap. What had happened was that in all of these three cases, counsel had proved in what, for the time at least, was meticulous detail what the cost of future care would be for these badly injured plaintiffs. There were two quadriplegics, and of course the Tino child was horribly brain damaged. And they proved what the actual cost would be of full-time home attendance and home care, and they called actuarial evidence in rudimentary form as we would know it now in our enlightened age, but who took into account such things as inflation and came up with a present value for the cost of this kind of home care, and it turned out to be some very large figures. Whether the defense counsel in those cases were caught by surprise or whether they just didn't have any evidence to contradict it, the point is they didn't. The trial judges only had the evidence before them of these costs and what the present value was, and to their credit, they acted on it, even though they gave awards that were very dramatically different than anything that had gone before. In the Andrews case, Mr. Justice Kirby actually put a figure on each separate head of future damages. In Tino, Mr. Justice Keith was reluctant to do that because of this line of cases that said that he shouldn't do that, but he indicated in his judgment what all the various heads were, how much they would cost, but then he came to a rolled-up figure for the cost of future care, which was $750,000 under that heading. The non-pecuniary general damages in those three cases range from $150,000 to $200,000. Now, those cases all came to the courts of appeal in 1975 and 1976. The Western cases came to the courts of appeal first, and the Western courts rejected the cost of home care, a private hospital, as they put it, as the standard. They said defendants just simply shouldn't have to bear the burden of the plaintiff having their own private hospital. And as a result, they greatly reduced the damages. The Ontario Court of Appeal, which heard the Tino appeal shortly after the Western cases were heard and decided, respectfully disagreed and accepted the home care standard and said, and went on to say, following the English cases, that the pecuniary general damages should be itemized, which they proceeded to do, and they came up with $675,000 rather than $750,000. These three courts of appeal differed widely in their response to using the discount rate as a means of providing for inflation in the award. Ontario accepting it, the Ontario Court of Appeal accepting it, and the Western courts rejecting it. Well, these cases, as we all know, revolutionized the approach to damages, especially in Ontario. The trial judges liked the judgments, and they proceeded to follow it. Counsel hired the witnesses that were necessary to prove these kinds of damages, and especially when Tino was confirmed by the Court of Appeal, the trial judges unanimously followed it, and a number of large judgments and settlements resulted. In 1978, all three cases got to the Supreme Court of Canada at the same time, and the Supreme Court of Canada, therefore, had to deal with all of these issues, or a number of them, and they tried, albeit, as I'll point out, somewhat unsuccessfully, to give a definitive judgment on all of these issues. But the issues that were before the court in the trilogy in 1978 were, first of all, the propriety of the breakdown of damages, the use of actuarial and economic evidence at all, because there was some doubt in the English cases as to whether that kind of evidence should be used, could be used, the method of dealing with the effects of inflation on awards that were to cover expenses over a long period of time, the standard of care, contingencies, the effect of income tax on this long period of future care, loss of future earnings, and this whole question of what the proper amount was for non-pecuniary general damages. Well, as I say, the Supreme Court of Canada attempted to lay down general principles, and they did on many of those headings, but unfortunately clouded the picture on a number of very important issues. They did settle the question of the so-called global award. They laid that to rest for all time. Mr. Justice Dixon said, in the Andrews case, he said, the method of assessing damages in separate amounts, as has been done in this case, in my opinion, is a sound one. It is the only way in which any meaningful review of the award is possible on appeal, and the only way of affording reasonable guidance in future cases. Equally important, it discloses to the litigants and their advisors the components of the overall award, assuring them that each of the various heads of damages going to make up the claim has been given thoughtful consideration. They confirmed the use of actuaries, and I think of economists, was the way that the courts had to go to find out how to treat some of these issues. The Supreme Court of Canada accepted that the effect of inflation on these future loss of income and future care cost components had to be taken into account, or there would be a shortfall. They recognized that the current high interest rates, which an award could be invested at, reflected anticipated inflation and therefore had to be discounted in order to come up with the proper award. Unfortunately, they made a calculation for the purpose of the trilogy that was based on a 1968 to 1973 estimate of inflation of 3.5%. But they compared it with the investment rates current in 1978, 10.5%, which reflected, of course, a much higher level of inflation that we were experiencing at that time, and they came up with this discount rate of 7%, which attracted a great deal of controversy. Fortunately, Mr. Justice Dixon said that the discount rate was a matter of fact to be decided on the evidence in each case, and subsequent judges seized on that statement in uniformly, almost uniformly, rejecting the 7% figure in the later cases. The Supreme Court of Canada accepted the home care standard, if that's what the evidence in the case indicated. And they laid down that a plaintiff did not have to accept less than adequate care because it was cheaper, to use the words of Martin Wonder, who argued this aspect of the case in the Supreme Court of Canada. A plaintiff didn't have to accept bargain basement care. In a later case, Lewis versus Todd, Mr. Justice Dixon said of the trilogy that what they were trying to do in that case was as follows. What the Supreme Court of Canada did say in the trilogy was that the prime purpose of the court was to assure that the terribly injured plaintiffs should be adequately cared for during the rest of their lives. So they accepted that standard. The Supreme Court of Canada laid to rest another area of some controversy with respect to the loss of future earnings. They said that the loss of future earnings should be calculated on the pre-accident life expectancy, and that a defendant couldn't say, well, by the accident I've reduced your working life expectancy from 50 years to 5 years because you're only going to live 5 years, and therefore I should only have to pay your loss of income for 5 years. The Supreme Court of Canada laid that to rest, although the English cases had gone the other way. And it's interesting that since that time, the English cases have reversed themselves and have followed the lead of the Supreme Court of Canada on this issue. The question of income tax on the award was not really dealt with in the trilogy at all, and that was left to be dealt with in later cases and isn't really finally decided. The point is, of course, that when you set aside this sum of money actuarially calculated to provide for the cost of future care, when you invest that money at today's rates, it's going to attract a lot of income tax in each year that you get the interest on the invested money, and if you don't provide the plaintiff with enough money not only to pay the expenses but to pay the income tax on the invested money, there is going to be a shortfall. The Supreme Court of Canada in the trilogy didn't allow anything for income tax, but that was in large part because the biggest part of the cost of future care in those cases was the cost of a full-time attendant, which in itself was deductible under the Income Tax Act. And so there wasn't a large income tax component to the calculation. And secondly, because the plaintiffs simply didn't call any competent evidence on that issue at the trial in 1974. Who even knew about that aspect of it? So that was really left open in the trilogy. Now, on the issue of non-pecuniary damages, the Supreme Court of Canada, of course, came to their very controversial result with a limitation of $100,000. They felt that was all it should be, and it should be consistent all across the country. So one must keep in mind the basis upon which they did that. It was done on the assumption that in these cases of massive personal injury and total disability, that the full cost of care was provided for, so that these injured plaintiffs would be without necessity for the rest of their life. And having provided that amount, then the Supreme Court of Canada felt that that they had to wipe out extravagant claims, as they put it. They were concerned about the American experience and the insurance premiums. Of course, at that time, the judges' wages still hadn't gone through, and the Supreme Court of Canada was worried about judges' insurance premiums just like everybody else. The only people that are not worried about the high cost of automobile insurance premiums are plaintiffs' lawyers. They're never concerned about the raise in them, but judges apparently are. Well, following the trilogy, the Supreme Court of Canada, I'm sure, felt that they had decided the case once, this issue once and for all. They'd never have to hear about it again. It didn't work out that way. There were two areas especially that attracted much criticism from the academic community, which finally took an interest in this area, from the practicing bar, and in mute but unmistakable fashion from the rest of the bench. The academic criticism unanswerably demonstrated that the use of the 7% discount rate and the failure to provide an allowance for the income tax on the award would inevitably produce a shortfall for all of these injured plaintiffs. There was just no answer to the arguments that were made in these academic journals. As a result, judges and lawyers seized on what Mr. Justice Dixon said about the factual issue, and in the subsequent cases after the trilogy, saw literally teams of expert actuaries and economists expounding on why 70% was not right and a 2 and 3% figure was. Poor John Deutsch, whose 3.5% figure in 1968 to 1973 had been bandied around by the Supreme Court of Canada, must have been pretty upset at the way his name was taken in vain by all of these experts. He didn't really mean that at all, but he was taken out of context by the Supreme Court of Canada. In addition, no defense counsel could produce a competent actuary or economist who would argue against a 3% figure. You might get one that might say in one or two short-term cases 4%, but that was about all. Now, the Ontario Court of Appeal complicated matters somewhat because in a case called Lewis versus Todd, which was a fatal accident case, which was about the first case to come before the court after the decision in the trilogy, the Court of Appeal reversed Mr. Justice Henry, who had used, in effect, a 2.5% discount rate in the trial in 1976, and they said, in a very short judgment, that Supreme Court of Canada had said 7%, and that's what it's got to be, and that's what they used, and they reduced a very large award to a very small award. This turned out to be an aberration because no other judges on the trial bench, and even the Court of Appeal, differently constituted, wouldn't follow it. So Lewis and Todd was really an aberration, but there it was. Lewis and Todd itself went to the Supreme Court of Canada and was decided last fall, and the judgment of the Supreme Court of Canada restored Mr. Justice Henry's judgment, and the Supreme Court of Canada referred to the storm of criticism about the 7% rate, and they reaffirmed that it was a question of fact. The evidence in Lewis versus Todd supported 2.5%, and that's what it was. Another result of all of this controversy was that the Chief Justice appointed a committee chaired by Mr. Justice Morden to see whether the discount rate ought to be fixed. The result of that committee was that the 2.5% rate was fixed by Rule 267A, which fixes that rate for inflation, leaves open the question of productivity and investment expense and the like, which might further affect the rate. On the question of income tax, which, as I say, was really left open by the Supreme Court of Canada, although they specifically didn't make any allowance for it, the Ontario courts have felt free to consider the incidence of tax on these awards, both in the cost of future care and personal injury cases, and on the loss of income or dependency in the fatal accident cases, and make what's called a gross up of the award to provide for the income tax liability where the evidence is there to support such a claim. And actuaries and tax accountants are quite able and willing to give this evidence, and on the higher levels of awards, that can be a very significant amount indeed. It can increase a federal accidents award in the $400,000 range by as much as $200,000 to $250,000. So we're not talking about peanuts. On the non-pecuniary loss, the $100,000 limit, the lower courts have really chafed under that limit, and they weren't sure just how to deal with it. Well, there's been a number of developments in that area. The Ontario Court of Appeal and other courts have held, first of all, that it's not a sliding scale. You don't look at the most serious cases being $100,000 and everything else works down from that. It's only a maximum to be awarded in certain defined instances. Mr. Justice Zuber said in a case called Richards versus B&B, "We do not accept the proposition that these three cases have established a scale from which all other personal injury cases are to be measured. They have, it seems, established a rough upper limit of assessment of non-pecuniary general damages for those plaintiffs who have been made economically whole by providing for future care, the replacement of loss of income and assessments for other pecuniary losses." Other cases have held that the award can be increased by inflation. There have been a couple $125,000 awards on the basis that there's been inflationary increases since 1978. Other cases have held, Fenn versus Peterborough, where there has been tremendous pain by from the scars resulting from a fire. That in itself can affect the award. It's yet to be decided, I think, what an award should be in those cases where there has been tremendous disability, but not measurable in future economic loss. The very young infant that is badly injured but may well be able to do something, but you don't know what the loss of income is. I'm still to be determined whether there's a $100,000 ceiling on that kind of injury. The question of the contingencies was dealt with in some detail by the Supreme Court of Canada and was as well by the Court of Appeal in the Yatino case. It's now perfectly clear that the courts will consider positive contingencies as well as negative contingencies. It used to be that contingencies were always a deduction, and in fatal accidents where there was a double deduction. There was already the built-in contingency of death in the actuarial figures, and then the courts took off another 10, 20, or 30%. Now, especially if there's evidence available that shows the contingencies go the other way, that the prospects are just as likely that or more likely that the damages would be higher, the loss of income would be greater, the courts are quite prepared to rather than make a deduction for contingencies, make an add-on in a proper case, and the trilogy stands for that proposition. The question of the productivity was really not touched on as well by the trilogy, but in the Lewis versus Todd case that I just referred you to, where Mr. Justice Henry in the trial division had referred to the fact that policemen's salaries, this was a deceased policeman in Toronto, policemen's salaries had on the evidence increased much faster than inflation. And as a result, he included a productivity allowance, and he did so by reducing the discount rate even further because of the evidence of the great productivity. The Court of Appeal had disallowed that. The Supreme Court of Canada said last fall on that issue, productivity was not raised as a factor in the trilogy, but I consider it an appropriate component of a damage award in a proper case. There was evidence to support the 2% figure selected by the trial judge. So that has opened up the productivity field again if you can get the evidence on it. Now, there has been a very dramatic extension of damages in these cases under the Family Law Reform Act. And I haven't the time here, and I don't think this lecture is the place anyways to deal with that in any detail. But you have to keep in mind that there is a whole new group of people that have claims for damages for personal injuries when their father, mother, son, etc. has been injured, not just for the services they render to the injured person, but for the losses they themselves suffer by the lack of the guidance, care, support, etc. There's a great many pitfalls and conflicts of interest that are created by the legislation that you really have to study and be careful of. What you should know, however, is that in October 1980, the Supreme Court of Canada came down with a decision in a case called Wolk versus Halverson. I don't think it's yet reported. It's W-O-E-L-K versus Halverson. Now, that case involved the consideration of a somewhat similar statute in Alberta, which had given statutory recognition to a type of loss of consortium claim, somewhat different than the Family Law Reform Act, but it gave a statutory basis for that kind of a claim. The trial court had awarded $10,000 under this loss of consortium heading in this particular case. Alberta Court of Appeal referred to all of the old cases that dealt with loss of consortium, and they reversed the judgment and awarded $100. They said it should just be nominal damages because we don't pay much attention to this kind of a claim. The Supreme Court of Canada restored the $10,000 award, and what they said was, if I can get this quotation, they said this: "It is now clear that in Alberta, the enactment of Section 35 has extended the right of action for a loss of consortium to wives, and by its statutory pronouncement has created a new cause of action, which must be approached freed from the limitations imposed by the earlier decisions in the common law. In my opinion, it is not open to the court to treat the new cause of action as trivial and deserving of only token awards." So it's perfectly clear that the claims under the new Family Law Reform Act, the new claims that have been created, can't be treated by the courts as trivial. They have to be given some effect too. Now, most of what I've said earlier deals with, applies as well to fatal accident claims, and there's one or two other considerations in the fatal accident claims that I do want to address myself to. Awards in fatal accidents have, as I've indicated earlier, dramatically increased. What the courts are doing now is to take a deceased wage earner's income, and they first of all will deduct the income tax. And from that, there was a period of time in the mid-'70s when you took the gross amount because of the Gehrman versus Lavoie case. That was reversed at the same time that the trilogy was decided. So you take the after-tax income of the wage earner. You then reduce that by the amount spent by the deceased on his own personal food, etc., food, clothing, etc. The accepted figure is somewhere around 25%. So you've got 70%, approximately 70 to 75% of the after-tax income, and then the courts capitalize that figure. That is the dependency, using the inflation discount rate, the 2.5%, affected by perhaps 0.5% for investment expenses for the widow, and perhaps 1%, perhaps nothing, perhaps more for productivity, if you can prove it. And then they take into account the estimate of the pension lost if the wage earner was in a pensionable job. And they take into account such things in a proper case as acceleration of the estate or diminution of the estate that the widow might have gotten more years down the road. And then there's an add-on for the allowance for guidance and the training and household assistance, again, if it's applicable. And then when you get that figure, and that's already a fairly large figure if the man was making any kind of a wage, then that figure, if the evidence supports it, has to be grossed up for this income tax, the component that the widow is going to have to pay on the income aspect of the award, and as I say, that can be 50 to 60 to 70%. So that can result in some very large awards, but that's the way that the Julian case was calculated, and that's the way that the council doing this kind of work are calculating these damages these days. There's another little wrinkle. The Court of Appeal in Julian referred to a recent case in England called Cookson versus Knowles, which said that what you should do in a fatal accidents case is calculate the damages from the date of the accident to the date of the trial. In other words, the loss of income from the date of the accident to the date of the trial. And then make a new calculation from the date of the trial based on the actuarial projections from that point on. And the Court of Appeal referred to that method of doing it with approval. And that tends to increase damages rather than reduce them. Another development of interest that I'm just going to touch on here is the question of interest. The new legislation dealing with prejudgment and post-judgment interest has gone a long way to make damage awards, personal injuries, fair ones, and it has ended the disability that was caused by the shortfall that was caused by actuarial calculations that were made as of the date of the accident or the date of the trial, but the money not paid until several years later pending appeals. It's also ended the scandal of frivolous free appeals that some insurance companies took because they knew they only had to pay interest at 5% on the judgments, but they could invest the money at much higher rates and, in effect, pay for the appeals out of the interest difference. The award of bank rate interest from the date of the judgment has ended all of that. And the last thing that I want to talk about is the question of lump sum versus, the second last thing I want to talk about is lump sum versus periodic payments. And all I'll say there is that in the trilogy, Mr. Justice Dixon lamented the fact that the courts had no jurisdiction to make that kind of award and opined that it would be lovely if only that could be done. The result was that the Chief Justice of Ontario set up another committee under Mr. Justice Holland to see whether that really was a good idea and whether it could be done. Well, Mr. Justice Holland heard from a lot of people, academics, insurance companies, and a lot of other people, and his committee concluded that the problems and disadvantages of such a system far outweighed the advantages, except on a consent matter. For a more complete review, one should read Mr. Justice Holland's report, which is on that issue quite worth reading. But it really is pie in the sky, and it does not, and it cannot work except on a consent arrangement, and I expect that our rules will be amended to allow that to be done. The last point that I mentioned in my paper is the question of structured settlements, and that's again something that we all have to be aware of because they are available and they are increasingly used and they are very useful in certain circumstances, and I think in certain limited circumstances, but in those circumstances they are very good indeed. The whole benefit of them is that they're not taxable. Once you have a structure set up, Revenue Canada has agreed in several opinions that that money comes out on a periodic basis over a long period of time completely tax-free. On the other hand, they are totally inflexible. The periodic payments that you make today over a period of time, they cannot be changed. You can allow for increases by estimating inflation and the like, but if you're wrong, then you're wrong and they can't be changed. In these structured settlements, the plaintiff accepts all the risk. Accepts the risk that increases in the cost of living will be greater than the increase in the periodic payments. Accepts the risk that the tax laws might change. Accepts the risk that the annuity company which owns the annuity might not remain solvent over 50 or 60 years. The defendant, on the other hand, accepts no risk. He gets a complete release. Now, structured settlements have their place, but they are not, again, the panacea that will solve every problem. Now, in the last decade, the courts and legislatures have come a long way in developing methods to meet the standard that meet the principle that I outlined earlier. Mr. Justice Dixon said recently in the Lewis and Todd case, the niggardly approach sometimes noted in the past is abandoned, and greater amounts are awarded, in my view, properly. Imagine the Supreme Court of Canada saying that, and greater amounts are awarded, in my view, properly in cases of severe personal injury or death. Now, from the analysis, it can be seen that the major outlines of the law are now pretty clear, and I don't think in the next few years that we're going to see any major changes in these principles. What is going to happen is that through the imaginative use by industrious counsel of the proper evidence, these larger awards are going to be made, which will truly put the injured person in the same position as he would have been if there hadn't been any wrong. But the use of these principles is entirely dependent on the evidence that we bring before the courts, and we have a corresponding very heavy duty to ensure that that evidence is in fact brought before the court in every proper case. Despite these advances, there's still a lot to do. There's still legislative reform necessary in many areas: larger no-fault benefits, increased insurance limits, interest payable on insurance limits from the date that the money should have been paid, the compulsory insurance all across the country, fairer tax treatment of injured plaintiffs so we don't get into a lot of these gross-up problems, and making sure that the bar is educated to get this evidence before the court are all tasks that we're going to have to undertake and undertake well. Thank you very much.
Thank you very much indeed, Earl.